230 matter, serial number 80, Prithvish MK for petitioner, connected matter, Ajay J. Nandalike.
Yes.
This is that recruitment matter, where
Yes, yes.
KG had to argue only 2 points.
Yes.
The first point was regarding Kpcl being a company and the rules and regulations. I have a memo, I'll just file it one.
Yes.
My colleague. Just 1 minute, my colleague has it, just 1 minute.
19/11/25. This notification.
That is past the memo, I'll explain the.
Yes.
Memo regarding the company.
Yes, Mr. Rich.
Lordships, I sought for 2 queries, my lords, with regard to the C&R rules, my lords. Pursuant to board resolution, the C&R rules came to be. In that sense, it's not a C&R rule; it's a decision. For internal governance of the petitioner respondent company, my lords, which has ought to be done. What is important is, my lords, by very board resolution, we sought to modify, my lords, saying that, my lords, there will be no viva voce, but it will be on the basis of examination, my lords.
Where is that?
That board resolution is also produced, page 27, 20.
Just for articles of association. You can just show.
Page 14, maybe kindly seen for a moment, my lords.
Yes.
Power to appoint the
Clause 7, my lords.
Yes.
power to appoint any person.
Clause, serial number 33, certain powers of the board,
Yes.
without prejudice to the general powers conferred under section 291 of the Act and so far
One of Companies Act.
Companies Act, my lords.
Yes.
Then, my lords, clause 7, to appoint any person to accept and hold in trust for the company any property so and so, or which is interested for the purpose and to execute all such documents. Then which is the other one? Clause.
To appoint any person, that's all.
Then, my lord, your lordship will kindly take to the second resolution. I mean, this is the board, my lord. Recruitment rule starts at page 22.
Yes.
This is, my lords,
Board meeting of
the 4th January 1992.
Yes.
This is to inform that 130th meeting of the board director of corporation will be held on Wednesday, 18th January 1992.
Yes.
Then, my lords, minutes of the meeting. Your lordships will get this is 25 at serial, right at the bottom of the page, my lords, at page 25. Cadre and recruitment and promotion rules.
Yes.
The managing director explained that the proposal before the board was mainly a codification of the existing rules for recruitment and promotion of corporate cadre employees, except for certain improvement relating to time-bound endorsement scheme and promotion policy. It was pointed out that in the proposal scheme, seniority has been given importance in promotion, so and so. Further, the concept of bounded endorsement, so and so. Based on the information, the rules had to be circulated to various unions, associations representing the corporate cadre, the employees, and filled up in the so and so. Then, pursuant to that, my lords, your lordship may kindly see this is pursuant to which it has come into effect. That is that document number 2, my lords.
Yes.
Then 1998 is at page 27, document number 3,
Yes.
dated 16th June 1998, my lord.
Yes.
Your lordships will get it in the last page, my lords.
Yes.
Item number 10, C&R rules modification.
Yes.
The managing committee informed that the board of the earlier CROs has been approved by the board earlier either, but the certain associations have sought discussion on the structure. The board in the 131st meeting decided the subcommittee could give one or more hearing to all the associations. According to the subcommittee completed the hearing, the board further in its 148th meeting decided that the MD might make suitable proposal for getting them vetted of 2 nominees so and so, my lords. The board noted the provisions has been made for 10% direct recruitment to the post of so and so, modification to bring about uniformity in the Department of Promotion Committee cadre, career promotion of weightage to rural weightage and so upgradation of course, rationalization later. So resolved that revised C&R rules as notified by the agenda notes and so may be approved and adopted in the corporation. This last word is in supersession of the existing C&R
Yes.
rules. So, my lords, pursuant to which it has been done. So, therefore, my lords, what is interesting is, my lords, neither the 1996, I mean,
1992 and
no,
1997.
no, the notification of the year 1997, my lords, has not been sought to be challenged. There is a specific direction to go about with the 1997.
Yes.
We have implemented that, my lords. Assuming for a moment, if I had not done that, they would have said that you have violated the court order. This is amended resolution.
Yes.
You cannot go back to the old C&R rules when there's a board resolution. Either way, they would have said you have not done this, my lords. So therefore, we have gone strictly as per the court direction as well as and that notification has not sought to be challenged. The recruitment notification of 1997 has not, 2017 has not sought to be challenged, my lords. Then with regard to Mano's second query, your lordships were pleased to point out with regard to Hyderabad, Karnataka and non-Hyderabad, Karnataka, my lords.
Yes.
Insofar as that is concerned, my lords, if your lordship sees the notification, first notification is of the where is it?
Can I just see? Writ petition 950. Not may take writ petition 953 of 2026. Writ petition.
Yes. What is that you want to be reliant?
My lord, there are two things, my lord. So, your lordship, the notification is of the year 2017,
Recruitment notification. This is circular of
2016. Before that, my lord, there's a state government circular dated 16th November 2016, my lord.
Yes.
That is Z2 at, my lords.
Yes.
That is at page 236. And a clarification notification dated 3/6/2025, which is at page 237, my lords.
ಯಾವ writ petition?
That is WP number, my lords, 39094 of 2025. Correct?
Yes.
39094 of 2025.
Sir, 953 of 20.
My learned friend says 953, court officer. My apologies, 953.
953.
953 court, sir.
209.
953.
953, my lords. There is two government circulars dated 16th November 2016 and 3rd June.
No, 953.
Next is G page 209.
953 ಅಲ್ಲ.
Correct.
953 is filed by that you. Annexure?
Annexure G, my lords, page 209. I think it's
But it's common. Everybody has filed it.
Yes, yes. Oh, it is. Yes.
the question is regarding HK and non-HK, my lords, in this
Not 9.
209 Annexure G.
Yes.
Manoj, as per the notification, just two facts before I go to this. 2016 is a notification, Manoj, the government circular.
Yes.
The recruitment notification is of the year 2017. That is dated, notification is dated 38/2017 notification, my lord.
Yes.
As per that notification, my lords, there are notification for recruitment for HKE and non-HKE. But the examination is one, my lords.
Yes.
Now, my lords, keeping that in mind, my lords, your lordship may kindly turn to 3/6/2025 notification, which clarifies, that is annexure G1, page 210, my lords, which clarifies clause 2, my lords, which clarifies 16/11/2016 notification
Yes.
at page 211, serial number 2, my lords,
Yes.
which says that, my lords, as your lordships are aware, like Shasharu, reservation amendment was brought about reservation for HK region, is saying that people in that region shall be given predominance.
Yes.
No, even though we had two lists, HKE and non-HKE, the process of recruitment is,
Yes.
first we fill up all the non-HKE, my lords.
Yes.
That means whoever comes on merit, even an HKE person comes on merit, in a non-HKE, we fill him up.
Yes.
We fill up. Then comes the non-HKE, the main HKE. The main grievance of the petitioners herein is, first you fill up the HKE, because there are two different things. Then you go to non-HKE, and there are two distinctions. That is not the object of the amendment to the.
Where you have stated that recruitment process will, that first will fill up that.
That is what is stated in page 210, serial number 2. my lord. It's only clarifying the 16/11 notification, my lord. It's page 211.
Yes.
Point number 2, ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ವೃಂದಗಳ ಹುದ್ದೆಯನ್ನು ನೇಮಕಾತಿ ಪ್ರತ್ಯೇಕ ನೇಮಕಾತಿ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ಒಂದೇ ಪರೀಕ್ಷೆ ಕೈಗೊಂಡಾಗ.
That is, my lord, in the present case, there earlier, one of the concepts is they should hold separate examination, what my learned friend, for HKE and non-HKE, my lord. That will be arbitrary for the simple reason, for one recruitment, you cannot have two tests. One may be tougher, one may be easier, my lord. So therefore, we conducted one test, but two streams of recruit.
Why that government has issued such a circular that you have to conduct two exams separately?
That is why we sought to clarify, that is why confusion has created.
This is a clarification circular.
Yes, yes, your lordship may kindly see at page number 210, my lords. It refers to the circular dated 16/11/2016, my lord, saying that lot of confusion has occurred because of this notification, and they have sought to.
Suppose if the recruitment is for Hyderabad, then it is, if it is for central, then it will come into a different portal. That's when they will do separate examination. All confusion.
Yes.
Your lordship may kindly turn to G2 also, my lords, 212, my lords. The circular dated 10/12/2025 was published on Kpcl website, wherein serial number 3 it is stated the selection list will be prepared by the government order dated 3/6/2025, which I just, my lords,
Yes.
got. That is, my lords, the G1, 3/6/2025 G1, my lords. Subsequently, certain candidates raised objections stating that since recruitment process commenced in 2017 under the rules dated 16/11/2016, that is annexure G, my lords,
Yes.
applying the 2005 is inappropriate. They have requested the withdrawal of the notification dated 10/12/2025 and the preparation of selection list as per the 2016 rules. In this regard, it is hereby stated that Kpcl will come under the circular dated 16/11/2016 and further clarified that the notification dated 3/6/2025, occurring both the notification applicable in the examination dated 27/12/2025 and 28/12/2025. Meaning to say, my lords, the examination is one.
Yes.
The recruitment process is for HKE and non-HKE. It's like something like, my lord, for example,
What he has read, 211, bottom,
please, my lords.
bottom.
Accordingly, both notifications are applicable to the examination.
No, no, no. 211 annexure G1.
Please, my lord, I'll go.
3/6/2020.
Please, my lord. That
After
is,
that column, you read that bottom.
what, ಮುಂದೆ,
You read Ajay. Yes.
ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ವೃಂದ, I'm reading column number 2.
no, no, no,
No, no,
this
I
one,
want to read the-
bottom portion.
ಮುಂದುವರೆದು ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ವೃಂದಗಳ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ಈಗಾಗಲೇ ನೀಡಿರುವ ಸೂಚನೆಗಳಂತೆ ಕಡ್ಡಾಯವಾಗಿ ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ವೃಂದಗಳ ಹುದ್ದೆಗಳ ಪ್ರತ್ಯೇಕ ನೇಮಕಾತಿ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ಪ್ರತ್ಯೇಕ ಪರೀಕ್ಷೆಗಳನ್ನು ಕೈಗೊಳ್ಳಲು ಸೂಚಿಸಿದೆ. ಇದರಲ್ಲಿ ಸಂಬಂಧಪಟ್ಟ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಗಳನ್ನೆಲ್ಲ ನೇರ ಹೊಣೆಗಾರಿಕೆ ಸರ್. This is in respect, this would apply because it was a re-examination. We were required to follow the 2016 circular.
Yes.
So what we are saying is that insofar as the clarification which is given at point number 2 is concerned, that is exactly what is there in the 2016 circular also. 2016 circular, my lords, we have to just go back 1 minute, my lords. 2016 circular is at page 209.
Yes.
So I just read the 4th point there, my lords.
Yes.
ಮೆರಿಟ್ ಪಟ್ಟಿಯಿಂದ ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ತಯಾರಿಸುವಾಗ ಮೊದಲಾಗಿ ಮಿಕ್ಕುಳಿದ ವೃಂದಗಳ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳನ್ನು ಪರಿಗಣಿಸಿ.
You are saying that even though that now you are conducting the examination, it is effect from 2017.
It is with effect from 2017.
Because 2016 was the original notification, 2017 is our notification. And ultimately, Manoj, including when we are making, for example, Manoj, HKE and non-HKE, we have reservation for scheduled caste, scheduled tribe, backward classes and general merit. Manoj.
Yes.
So among the HKE people, even non-HKE, we have this. So therefore, Manoj, to bifurcate, it was becoming difficult for HKE and non-HKE. So we had 2 streams, Manoj.
Yes.
But 1 examination, 2 streams.
Yes.
But when you're going ahead with selection, Manoj, we are filling up the non-HKE first.
Yes.
Those who are in merit of HKE region will take that, Manoj, like something like scheduled caste. Even though they are coming on scheduled caste, more meritorious will take the general category. That's the whole purpose, Manoj.
Yes.
And one more, again, the repetition of the same argument.
Yes.
This was always there, Manoj. So therefore, to find out saying that it has been done, something
Yes.
does not arise, Manoj. So these are the 2
Yes.
points, Manoj. And ultimately, Manoj, the question is, Manoj, they are trying no prejudice by the whole argument, Manoj. The person who has written the test, he cannot, no prejudice is caused to any of them or the whole earlier round of notification with regard to Kannada exam or negative marking, Manoj. If a lordship see both the judgment, only on the point that rules of the games have been changed in the sense no prior notice was given.
Yes.
Either for Kannada examination increasing from 100 to 150 or negative marking which was not known to them. This is only short point was what was done, Manoj.
Yes.
Therefore, Manoj, having complied with the earlier directions, Manoj, there is no infirmity, Manoj. Therefore, I am just
clarification insofar as this is concerned, my lord. Lordship may kindly see the 2
what is the proposition?
circular, my lord. First circular 16/11/2016, my lord.
What is the proposition?
Lordship,
Where is the court copy?
So this is the code. So this is your copy. So you just take.
Court officer. Just 2 minutes, I'll finish. Just 2 minutes.
Yeah, how do we?
Yes.
Okay, everybody.
16/11/2016.
16, condition number 2, I will read, my lord.
Yes.
That is, my lord, this circular was issued, my lord, regarding the method of recruitment for both Hyderabad, Karnataka and non-Hyderabad, Karnataka. There were some, several circulars were issued, my lord. There was some confusion regarding the method of our selection process to be conducted. But at that stage, my lord, this circular was issued on 16/11/2016.
Yes.
But it prescribed 4 types of, 4 conditions, my lord. The first one is, my lord, ದಿನಾಂಕ 22/5/15 ಸುತ್ತೋಲೆಯಲ್ಲಿ ನೀಡಲಾದ ಮಾರ್ಗಸೂಚಿಯು ಕರ್ನಾಟಕ ಲೋಕಸೇವಾ ಆಯೋಗದಿಂದ ಗೆಜೆಟ್ ಪ್ರೊಬೇಷನರ್ ರೂಲ್ಸ್ ಅಡಿಯಲ್ಲಿ ಕೈಗೊಳ್ಳಬಹುದಾದ ನೇಮಕಾತಿ ಮಾತ್ರ ಸೀಮಿತವಾಗಿರುತ್ತದೆ. ದಟ್ ಇಸ್ ರಿಸ್ಟ್ರಿಕ್ಟೆಡ್ ಓನ್ಲಿ ಟು ವಿವಿಧ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಗಳು ಇನ್ನು ಮುಂದೆ ಮಿಕ್ಕುಳಿದ ವೃಂದ ಹಾಗೂ ಸ್ಥಳೀಯ ವೃಂದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳಿಗೆ ಅರ್ಜಿ ಆಹ್ವಾನಿಸುವ ಅಧಿಸೂಚನೆಯನ್ನು ಪ್ರತ್ಯೇಕವಾಗಿ ಹೊರಡಿಸಿ ಪ್ರತ್ಯೇಕವಾಗಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ಕೈಗೊಂಡು ಆಯ್ಕೆ ಅಂತಿಮಗೊಳಿಸುವುದು. This is a condition which we are also bound to follow. The notification was issued pursuant to this condition.
Yes.
2 notifications were issued.
Yes.
My lord, with regard to conducting examination, my lord, there was some confusion. On the presumption that because of the confusion, they proceeded with the single examination. Now, my lord, during the pendency of these examination and during the pendency of the writ petition and matter went up to Supreme Court, my lord, they realized that there is a mistake. They should have conducted 2 separate exams. In the meantime, my lord, a circular came to be issued, that is 3/6/2025.
Yes.
I'll read 3/6/2025 preamble, why it was issued, my lord.
Yes.
Lord, Your Lordship got it?
Yes, yes.
ಕಲ್ಯಾಣ ಕರ್ನಾಟಕ ಪ್ರದೇಶ ಸ್ಥಳೀಯ ವ್ಯಕ್ತಿಗಳಿಗೆ ಮೀಸಲಿರಿಸುವ ನೇರ ನೇಮಕಾತಿ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡುವಲ್ಲಿ ವಿವಿಧ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಿಗಳು ಹಾಗೂ ಆಯ್ಕೆ ಪ್ರಾಧಿಕಾರಿಗಳು ಪಾಲಿಸಬೇಕಾದ ವಿಧಿವಿಧಾನಗಳ ಬಗ್ಗೆ ಅನೇಕ ಸುತ್ತೋಲೆಗಳನ್ನು ಹೊರಡಿಸಿದ್ದಾಗಿಯೂ ಆಯ್ಕೆ ಪ್ರಕ್ರಿಯೆ ತಯಾರಿಸುವಲ್ಲಿ ಆಯ್ಕೆ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಗಳು ಸದರಿ ಸುತ್ತೋಲೆಗಳನ್ನು ಸೂಚನೆಯನ್ನು ಅನುಷ್ಠಾನಗೊಳಿಸುವಲ್ಲಿ ಗೊಂದಲಗಳು ಉಂಟಾಗುತ್ತಿದ್ದು. This is the reason, my lord, there were several circulars issued in respect of these issues, my lord. Therefore, my lord, it was decided that final clarification be given. This is the final clarification that has been issued.
Yes.
Now, what it says, my lord, ಮುಖ್ಯವಾಗಿ ಸರ್ಕಾರ ದಿನಾಂಕ 15/6/22 ಸುತ್ತೋಲೆಯಲ್ಲಿ ವಿವಿಧ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಗಳು ಸ್ಥಳೀಯ ಹಾಗೂ ಮುಖ್ಯವಾದ ವೃಂದ ಹುದ್ದೆಗಳಿಗೆ ಪ್ರತ್ಯೇಕ ಅರ್ಜಿ ಆಹ್ವಾನಿಸಿ ಪ್ರತ್ಯೇಕವಾಗಿ ಸ್ಪರ್ಧಾತ್ಮಕ ಪರೀಕ್ಷೆಗಳನ್ನು ನಡೆಸಿ ಪ್ರತ್ಯೇಕವಾಗಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ಕೈಗೊಂಡು ಆಯ್ಕೆ ಪ್ರಕ್ರಿಯೆಗಳನ್ನು ಅಂತಿಮಗೊಳಿಸಲು ಸೂಚಿಸಿದ್ದಾಗಿಯೂ ಸದರಿ ಸೂಚನೆಗಳನ್ನು ಪಾಲಿಸದೆ ಅನೇಕ ಪ್ರಕರಣಗಳಲ್ಲಿ ಒಂದೇ ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸಿ ಒಂದೇ ಪರೀಕ್ಷೆ ನಡೆಸಿರುವ ಹಾಗೂ ಪ್ರತ್ಯೇಕ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ಒಂದೇ ಪರೀಕ್ಷೆ ನಡೆಸಿರುವ ಪ್ರಕರಣಗಳು ಬೆಳಕಿಗೆ ಬಂದಿರುತ್ತವೆ. This is also one of the such instances. Now, my lord, ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ರಾಜ್ಯದ ವಿವಿಧ ಸರ್ಕಾರಿ ಇಲಾಖೆಗಳ ನೇರ ನೇಮಕಾತಿ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡುವ ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ಪಾಲಿಸಬೇಕಾದ ಅಂಶಗಳ ಬಗ್ಗೆ ಈ ಕೆಳಕಂಡ ಸ್ಪಷ್ಟೀಕರಣ ನೀಡಲಾಗಿದೆ. Now, your lordship may kindly see, the first one relates to ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕಿದ ವೃಂದದ ಹುದ್ದೆಗಳಿಗೆ ಒಂದೇ ನೇಮಕಾತಿ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ಒಂದೇ ಪರೀಕ್ಷೆ ಕೈಗೊಂಡಾಗ what is the step to be taken? Next, my lord, ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕಿದ ವೃಂದದ ಹುದ್ದೆಗಳ ಪ್ರತ್ಯೇಕ ನೇಮಕಾತಿ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ಒಂದೇ ಪರೀಕ್ಷೆ ಕೈಗೊಂಡಾಗ. This is the one which is applicable to our case.
Yes.
ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಪಡೆಯಲಾಗಿರುವ ಆಯ್ಕೆಯನ್ನು ಪರಿಗಣಿಸದೆ ಮೆರಿಟ್ ಪಟ್ಟಿಯಿಂದ ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ತಯಾರಿಸುವಲ್ಲಿ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಮೊದಲಿಗೆ ಮಿಕ್ಕಿದ ವೃಂದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳಿಗೆ ಎದುರಾಗಿ ಪರಿಗಣಿಸಿ ಆಯ್ಕೆ ಪಟ್ಟಿ ತಯಾರಿಸುವುದು. ತದನಂತರ ಸ್ಥಳೀಯ ವೃಂದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳಿಗೆ ಪರಿಗಣಿಸಿ ಅರ್ಹ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳ ಆಯ್ಕೆ ಪಟ್ಟಿ ತಯಾರಿಸುವುದು. By conducting this kind of a process, my lord, there will be no injustice caused to Hyderabad, Karnataka persons.
Yes.
Therefore, my lord, finally what they say in the last paragraph say, ಮುಂದುವರೆದು ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕಿದ ವೃಂದದ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ಈಗಾಗಲೇ ನೀಡಿರುವ ಸೂಚನೆಗಳಂತೆ ಕಡ್ಡಾಯವಾಗಿ ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕಿದ ವೃಂದಗಳ ಹುದ್ದೆಗಳ ನೇಮಕಾತಿಗೆ ಪ್ರತ್ಯೇಕ ನೇಮಕಾತಿ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ಪ್ರತ್ಯೇಕ ಪರೀಕ್ಷೆಯನ್ನು ಕೈಗೊಳ್ಳಲು ಸೂಚಿಸಿದೆ. ತಪ್ಪಿದಲ್ಲಿ ಸಂಬಂಧಪಟ್ಟ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಿಗಳನ್ನೇ ನೇರ ಹೊಣೆಗಾರರನ್ನಾಗಿ ಮಾಡಲಾಗುವುದು. This is only in respect of future recruitment, my lord. They have specifically said that 2 separate notification and 2 separate selection process have to be conducted, failing which, my lord, they will be the person who is conducting contrary to this, my lord, will be held responsible. Therefore, my lord, considering this 3/6/2025 as a clarification, my lord, the respondents have proceeded with the selection process.
Given as my written note submission for your lordship's kind consideration, my lord. Page 8, my lord.
Yes.
I finished arguing on page 8, my lord. Just page 9. Page 9, last, my lord.
Yes.
The petitioner cannot be permitted to agitate, last paragraph in page 9, my lord.
Yes.
The petitioner cannot be permitted to agitate his grievance at a belated stage after writing the examination only with a view to take a chance if they are not performed well in the examination. Page 10, my lord, these are the 3 judgments which are given in the compilation, my lord.
Yes.
The petitioner seeks to distinguish on the ground in WP was filed on 24/12 when the exam was supposed to be held on 27/12. However, on 26/12 when the matter was listed, it was simply adjourned without even issuance of notice to the respondent. So all the petitions, my lords, are filed after writing the examination, my lords. Then page 11, my lords, one of the judgment insofar as statutory rules, what was thought to be argued, my lords. Under the Air India Corporation Act, they can be modified. The so-called rules are not statutory rules for the reason the statutory rules can only be issued by the government and has to be gazetted. The test is that it should be issued under some statutory provision and notified in the gazette. In the present, there is no pleading. Ultimately, my lords, and this is based on a board resolution. Even in a statutory corporation, my lords, it is to be done. Whereas this is a company, my lords. That's my respectful submission.
Yes. No, you want to make submission, Mr.
Largely, I think everything which I wanted to comment already is covered. Even that circular, Mr. Budget is already clarified that clause number 2 specifically covers those cases where notifications have already been issued. This case was 3rd of August 2017 already was issued. Now the direction is for future recruitment notification. That is also fairly covered. Just one point, now the Lordship is aware that this is the 3rd round where First examination challenge, second examination on the point of negative marking. Now, my lords, I'm told a submission was made that the impeding applicants that we represent were on the other side and we were challenging the previous examination. That is factually one untrue. Two, my lords, the candidates, my lords, they cannot be given a bite of the apple every time they write an examination. They don't succeed, stall the entire process. Now, of course, when the previous litigation was initiated, previous petitions are filed, I asked myself, my lords, were these contentions not available? At that time, my lords, they chose only to raise the negative marking issue. They chose not to raise any of these issues. Even though, my lords, admittedly, these contentions might have been available, they chose not to raise them. So they cannot be constantly permitted to raise new issues every time, my lords, merely by happenstance of the fact that they do not succeed in the recruitment.
Yes.
That's all, my lords. Therefore, my lords, all of these contentions, whether it's HK, separate exam, this, that, all that was available. So therefore, there's a threshold question as to whether they
Whether they have succeeded or not, the result has not come.
correct.
The Supreme Court said, after that unsuccessful
Marks have already been issued. They are out of the range.
They are fully aware.
I have produced a document, my lord, to show the statement.
The marks is
Lordship may kindly see the IFR impleading where I have specifically said, none of these petitioners, my lord, are within the zone of consideration. None of them. Page 99, my lord, Annex J.
in which
IFR impleading I have filed, my lord.
39094.
39094 of 2025.
now when the result has come,
Blood result
Marks
was
have been select list published, but marks have been
7th, my lord. And even the verification has also been held, my lord. On 28,
In fact, if
27, 28 verification of records also been held, my lord.
if your lordships are aware, the original note had pointed out to your lordship what are the steps which have to be taken. So the question of appointment order does not. I think it's in the list of dates which I produced in the initial at the time of seeking interim order.
yes,
My lord, your lordship may kindly see the statement which I produced, my lord. Along with the IFR impleading, my lord.
yes,
In WP 39094 of 25, my lord.
yes.
Page 99, my lord.
8th of January. Results.
8th of January, my lords.
8th of January.
Scores were notified, my lords.
Marks announced 8th of January.
8th of, examination was on 27th and 28th of December.
But they have filed before that.
No, only one person is filed before.
One person was filed without notice, matter was urgent. So no notice was filed insofar as that person is also called. Examination was 27th December,
Yes.
24th December,
Now, on what date? First date you have.
24th December, my lords.
24th December.
One petition had come,
But it is before announcing that result.
no, before the examination, my lords.
Before exam.
Before the examination, one petition came
Yes.
and no notice was issued, it simply it was urgent, my lords.
On 5th of January, the matter came up, my lords.
That is
5th of
after-
after the examination, 5th of January, that day notice was issued to me, my lords. On that day, notice was issued to all the respondents. Matter was listed on 8th.
No, but
Yes.
on that day, first when you are appeared, result was not announced.
No,
Exam is
No,
over.
my lords, 5th, I was not issued notice.
No, you have appeared on that day.
No, I appeared on 8th. 5th, my lords, matter came up for the first time before, my lords.
Yes. No, anyhow, that fifth matter has come.
Fifth,
Your appearance is not that important. Important is that case has been come before the
The lordships are right, my lord.
Yes.
And the result was on 8th. my lord.
8th.
On facts, that is right, my lord. So
Yes.
what your lord.
four aspects actually.
So therefore, my lord, on 8th, they knew the correct
But
state.
fifth case has posted before the court.
Correct.
Yes.
Only one of the writ petitions of 4 people.
Yes.
Everybody else is filed afterwards.
Yes.
That person also knows, I'm told, the recruitment, the notification in this case, Malas, was issued on 19th of November.
Yes.
At that time, Malas, his SLP was pending. So therefore, Malas, it's a classic case of trying to hedge his bets. He's taking his chances before the Honorable Supreme Court.
Yes.
19th of December, his SLP gets dismissed. I'm told, Malas, immediately after that, he files this.
Yes.
That conduct also needs to be deprecated, Malas. He waits. Will he succeed before the Supreme Court or not? Once it gets elected, then he comes there and challenges this.
My lord, it's
Almost
like
like it's
there-
keeping on.
No, that's maybe the correct. If it is succeeded in the Supreme Court, why do you want to go?
But immediately he
Allah,
would have challenged. he would have
I'll
challenged
put it this way, my lord. There are 9,482 candidates, my lord,
Yes.
for the post of 622.
Yes.
My lord, out of 9,000, my lord, somebody or the other will have something because it is not to his liking.
Yes.
The whole case is about saying that it should have been done like this. The question is whether it is arbitrary or uniformity is there. As appointed at the cost of repetition, my lord.
Yes.
Everybody knew what the original notification has not been challenged. Everybody is taking a chance at it, my lord. The question is scope of judicial review in the in such matters.
We'll consider.
My lord, page 99, my lord, Annex J, to show that none of the petitioners, my lord, were successful. Statement I have produced. my lord.
No, that may be true. They knows that after examination, it may be very tough. But
In both the exams, my lord, both the exams, they have failed to qualify, my lord.
But before result, they come, because actually that good students know that what is their result when they write an examination.
Correct.
Yes.
So this shows, my lord, your lordship may kindly see the Syed Burhan Ahmad, my lord. He had applied for AE electrical, my lord. Total number of posts available is 101.
Yes.
My lord, he has applied under category 2B.
Yes.
My lord, he had, in the exam held on 18/2/2024, my lord, he had secured 26.667.
Yes.
My lord, his ranking was 239 out of 3,517.
Yes.
Kindly note, my lord.
Yes.
Then, my lord, similarly, in the next examination that was held, my lord, he had secured 22.352 and he was 901st rank out of 1,620. my lord.
Yes.
Now, similarly, my lord, the next candidate, that Habiba,
Yes.
chemical supervisor and chemist, my lord,
Yes.
40 and 8 are the posts available. My lord, they have scored 10.667. My lord, out of the 635%, my lord, he had secured 209th rank.
Yes.
In the second examination, my lord, he had secured 107 out of 307th rank. Last got it.
Yes.
Similarly, my lord, Rashmi Balga, my lord, 62 is the post available. My lord, she has scored 24 marks. Rank is 44 out of 335.
Yes.
Not selected. Second exam also, my lord, she has scored 20 marks.
Yes.
My lord, of which, my lord, her ranking was at 119 out of 237.
Yes.
Then the last candidate, my lord, Kirti Kishore. My lord, the total number of posts available is 97.
Yes.
My lord, he has scored 48 marks.
Yes.
He stood at 21st rank, my lord, out of 186.
Yes.
Subsequently, my lord, 32.687. My lord, he stood at 84th rank, my lord, out of 108.
Yes.
Therefore, my lord,
Just one last point, I'm sorry, just, your Worship, kindly note, the examination was held on 19th, notification was issued on 19th November 2025.
Yes.
Examination was held on 27th December.
Yes.
Maybe they have 40 days, madam. If a person is aggrieved,
Yes.
he should come at the first instance, challenge the 19/11/2025 notification, assuming, madam, according to us, it's constructive res judicata, you cannot raise what you have not raised earlier, you cannot. Assuming you want to raise, you should have raised on 19/11. They write, all of them except one, madam.
Yes.
They write the examination.
Yes.
And the one person also does not move the court at the earliest question.
Yes.
After having written the examination, my lord, he loses the right to maintain the writ petition. My lord, I just want to show the compilation of judgment, one paragraph, page 108, to say that, my lord, he cannot waiver of appropriate reprobate and estoppel, my lord,
Yes.
and he's taking his chance, my lord.
Yes.
Page 108, para 38, my lord.
Last judgment.
Last judgment, my lord. The next aspect of the matter which requires consideration is that the contention of the writ petitioner is to the effect that the entire selection process was vitiated as eligibility criteria enshrined in the advertisement notice dated was recast by corrigendum dated so and so without any reasonable, without any justifiable reason. In order to consider this contention, regard may be had to the following case laws. In so and so, this court authoritatively declared that having participated in the selection process without any protest, it would not be open to the unsuccessful candidate to challenge the selection criteria subsequently. In so and so, an advertisement was issued inviting application for appointment to the post of so and so who had failed in the clear written test presented a writ petition, and they prayed for quashing the advertisement and the process of selection. They have pleaded that the advertisement and the test were ultra virus and the provisions of so and so, so and so, so and so, so and so. After referring to canteen of judgment on the principle of waiver and estoppel, this court did not entertain the challenge for the reason that the same would not be maintained after participation in the selection process. The pertinent observation of this court are as under. In view of the proposition laid on in the above noted judgment, it must be held that having taken part in the process of selection with full knowledge that the recruitment was being made under the general rules, the respondent have waived their right to question the advertisement or the methodology adopted by the board for making selection, and the learned single judge and division bench of the High Court committed great error by entertaining the grievance made by the respondent. Similarly, so and so, a process was initiated, so and so, so and so, so and so manner. Then page 109, Manoj, at page the paragraph 39, I'll just skip the other one.
Yes.
It is therefore tried that candidate having taken part in the selection process without any demo or protest cannot challenge the same of having been declared unsuccessful. The candidate cannot appropriate and reprobate at the same time. In other words, simply because the result of the selection process is not palatable to a candidate, he cannot allege that the process of interview was unfair or that there was some lacuna in the process. Therefore, we find that the writ petition in this petition could not have questioned before a court of law the rationale behind recasting the selection criteria, and they were fully looking to the part of so and so, so and so, so and so, Manoj, acquiescence and waiver. As your lordship rightly pointed out, Manoj, date of the examination on 27, they would have come to know what is the result, not on the 8th. The person who writes the exam, he knows where he stands on 27.
After 19.
The two things, either they should have immediately before having participated, he cannot. On 27th, he waits till 27, he knows what is the result, then he comes to the court. Therefore,
Just to clarify that aspect, I'm so sorry, just 2 minutes if your lordship will indulge me. To answer lordship's question, if my lords were to kindly take the 39094, the writ petition.
39094, yes.
39094.
Yes.
I'll just point out just the conduct of this, the petitioner, my lords, who filed a petition before the exam.
Yes.
39094, if my lords were to kindly take page 78.
Yes.
Kindly see page 78, my lords, the petitioner number 2. Kindly note the name.
Yes.
This was, my lords, a writ appeal filed against the order of the learned single judge, wherein the contention was that I was not put on notice of the fact that there would be negative marking in the examination. That writ appeal, my lords, your lordship should recollect, came to be allowed. In fact, the examination was set aside because this honorable court felt that the students ought to have been put on notice of the fact that there was negative marking. Then, my lords, kindly see what else. Then some of the respondents in the writ appeal approached the Honorable Supreme Court. Honorable Supreme Court rejected the SLPs. My lords will find that order at page 131, my lords.
131.
131, running on to page 132.
Yes.
Now kindly see the next page, 133. Same petitioner once again, my lords.
Yes.
What he does is, even though he succeeded before the division bench of this honorable court and succeeded before the Honorable Supreme Court, he files a review petition. Once again, kindly see what his ground at page 136, paragraph number 3.
Yes.
He essentially, the learned counsel appearing for the review petitioner submits that the court has erred in not considering the question whether fresh examination was required to be conducted with the stipulation of negative marking. This is the submission he makes. He submits that since the recruitment rules do not provide for negative marking, fresh examination containing negative marking ought not to have been directed. So now he says negative marking can never be applied. Then, my lords, against this is an order that is dated October 10th, 10th day of October 25.
Yes.
Against the rejection of his review petition, he files an SLP. That, my lords, will find at page 141.
Yes.
Same petitioner once again, my lords.
Yes.
And this came to be rejected on 19th of December. So all I'm trying to say, my lords, is just kindly note the conduct. At every single stage, this person seems to be trying to scuttle the process. And immediately after rejection of the SLP, he challenges this. If he was truly aggrieved by the fact that there was no 2 separate examinations for HK and non-HK, or that the C&R rules were not being complied with, I asked myself once, why could he not have challenged it even prior?
Yes.
So therefore, this is a case where he succeeds before the division bench.
Yes.
He files a review against his judgment in which he has succeeded, fails, goes to the Supreme Court, then once again challenges it. So, my lords, to stop an entire recruitment process now, which has been going on for about 8 years. 12 years. 12 years.
Yes.
At the behest of people like this, my lords, should not be permitted to be my respectful submission. In fact, it should be deprecated.
Yes.
I'm grateful.
That is not the
So, recruitment
that is decided on law. That is not, yes. Just because of that, we can't do anything. We have to be decided on that. Yes. Yes.
953 Lordship, petition. Annexure A Lordship. 953.
Yes.
This is regarding non-Hyderabad Karnataka recruitment notification. Lordship.
Yes.
There is a table, Your Lordship. At column number 8, Your Lordship, A electrical, page number 30, 30.
30. Yes.
There is a column number, there is a column, Your Lordship.
Yes.
At serial number 8, Your Lordship,
Yes.
AE electricals. 30 seats are open for the people who have applied in this notification, Your Lordship.
Yes.
30 seats. Lordship, see annexure A1, Your Lordship, page number 40.
Yes.
In that there is also column, Your Lordship. Serial number 2, A electrical, there are 71 seats are open for A electricals, Hyderabad Karnataka students, Your Lordship. Previously, how they used to do is, the person who has applied for Hyderabad Karnataka people can apply for both recruitment notification, Your Lordship. They can apply for NHK and HK. So people who have applied for both and paid the both fees, for them 101 seats are open, total 30 plus 71, Your Lordship. Both seats are open for them to get the merit, Your Lordship. Now, what have as per this impute 25 notification, Your Lordship, even the Hyderabad Karnataka have not students have not applied for the annexure A, Lordship, this notification. They are dumped to this 30 seats also, Lordship. That means I am not eligible for 30 seats also, Lordship.
Yes.
The preference is given to them. First preference is given to them, Your Lordship, as per this.
Yes.
So the 101 seats are also, if there are 101 Hyderabad Karnataka candidates who are eligible and who are having a great merit than me, they are given the seats.
That is what the rule is, Mr.
But this,
Whoever secured highest,
but what is the point of,
irrespective of reservation and all, they will be in the top.
but what is the point of
After
making
that
two
top-
notification?
Seniority, meritorious students has been selected, then it will come to that reservation.
But there was
What the rule
30
is?
seats was given to me earlier, Your Lordship. Only till 2025, whatever the 3 exams I was conducted,
Yes.
in all 3 exams they have followed this pattern. What they have done is, in my rejoinder, Your Lordship, I filed one willingness certificate. They used to give a willingness certificate. Whoever, after all the marks has been granted to them, whoever has applied to both of these application, the willingness certificate is given to them. They have to tick whether I want NHK post or non-NHK post. After this implement or judgment, the willingness concept is itself not there, Your Lordship.
That's
They are
not-
totally
that is
down to
wrong.
this.
You are, see,
I have no reservation at all by this means, Your Lordship. There is no point of making an extra day, Your
No,
Lordship.
no.
They should have.
Reservation is not that general merit. If you score more, you will get it.
Your Lordship,
See, to write an examination, they will also treat it as a general merit only in that ranking is concerned.
yes, Lordship.
See, if you score more than that other persons who are HK, you will be placed that.
But for previous 3 terms, Your Lordship, this method was followed. Your Lordship may see that they have filed one synopsis, Your Lordship, at
Yes.
page number 15, Your Lordship may see, page number 15 of their synopsis they filed.
Yes.
There they have admitted Kpcl has wrongly asked candidates for the willingness certificate. They themselves are admitting that they have wrongly.
See,
that means that till all these years they have been
That is
conducting
wrong.
by
What
wrong
they
method.
have done is wrong earlier. Now it is corrected.
They can't change the rules. The 3 times they have done it in the same manner. Now
You
they are
can't
changing.
deny the rights of that Hyderabad Karnataka. If they are scored, they will be selected in general.
They are-
After selection, option will be given. If they don't want that post, they will come back to that.
No. As per this 2025 election, the preference has to be given for them. If there are 101 of their candidates, they will be put to that list.
Yes.
My this thing will not open, Your Lordship.
No,
That's the thing.
You will get if you score more than that.
But there was 30 reservation was there for me earlier, Your Lordship.
Yes, yes.
That thing is itself not as per this.
Yes.
And Your Lordship,
Yes.
regarding locus in my case, Your Lordship, I'm giving some judgments, Your Lordship.
Modify.
Yes.
First judgment, Your Lordship. I'm just telling that they have raised a contention that I don't have eligibility to write Kannada. I am not required to write Kannada exam, so I cannot challenge a Kannada exam.
Yes.
That's their concern, Your Lordship.
Yes.
Your Lordship, first judgment, Your Lordship, Pratap Kishore Panda versus page number page number 14, Your Lordship.
14. Yes.
Para number 22, Your Lordship.
Yes.
Down below.
Have you given copy? You have received this? Yes. Yes.
The order question of which we must turn our attention, in which the appellants had locus standi.
Which paragraph you are reading?
Para number 22, Your Lordship.
22.
22.
The other question.
The other question to which we must turn our attention is whether the appellants had the locus standi to challenge the mode of the recruitment of the respondents. The High Court has held that since they were not of the reservation class, they did not have any locus standi to challenge the mode of recruitment of the respondents who were of the reserved class, on the principle that the unequals cannot be treated equals. While we accept the principle itself, we do not find in pertaining to the factual scenario here before us. The unputed factual position is that by virtue of the retrospective regularization, several respondents have gained seniority over the appellants. In light of that direct impact on them, the appellants would have the locus standi to challenge the validity of the appointment of the respondents. However, for reasons discussed above, the challenge allowed was not successful.
Yes.
So, Your Lordship, by the illegal method of them conducting the Kannada exam, Your Lordship, the whole yardstick has been changed, Your Lordship. I am put out of the previously I was at serial number 9, Lordship. By them making a wrong type of a Kannada exam, Lordship, I am put out of the list, Lordship. No.
Yes.
So when my final score is challenged, when my final score is, I am agreed by my final score. I am a person agreed to in this category, Lordship. So I can challenge the Kannada exam even if though I have not written, Lordship. And page number, Lordship, second judgment, Lordship. Page number 41, Your Lordship.
Yes. Yes.
In view of para number 49.
Page number?
Page number 41, para number 49.
Which is the judgment you are relying on? Citation, is it?
Gaurava Pardhan versus State of Rajasthan and others.
Yes, item number.
Item number second, Your Lordship.
Yes.
Page number 41, para number 49.
2018 11 SEC.
Yes, Your Lordship. If I may read the para number 49, Your Lordship.
Page?
Page number 41.
Yes. Para?
49.
Yes.
In view of the foregoing discussion, we are considered opinion that the candidates belonging to SC, ST, BC who have taken the relaxation of age were not entitled to be migrated to the unreserved vacancies. The state of Rajasthan has migrated such candidates who have not taken conscience of the age against the unreserved vacancy, which resulted in displacement of larger number of candidates who were entitled to selected against the unreserved category vacancy. The candidates belonging to unreserved category who could not have been appointed due to the migration of candidates belonging to SC, ST were clearly appointed due to the migration of the candidate belonging to SC, ST and entitled to the appointment which were denied to them basis of the above illegal interpretation of the state. We, however, take into notice that the fact that the reservation category candidates who have taken the benefit of age reductions were migrated into unreserved category and were working for more than past 5 years. The reserved category candidates who are now appointed on migration against the unreserved vacancy are not at fault in any manner. Hence, we are at opinion that SC, ST candidates who have been migrated in reserved vacancy are appointed and should not be displaced and allowed to continue in the respect post. On the other hand, unreserved candidates who could not be appointed to the above illegal immigration also entitled to the appointment in the merit. So what they have held is, Your Lordship, even though in this case the general merit have challenged the SC, ST category. In this case, it was the locus standi was challenged of the general merit candidate that they can't challenge the SC, ST. Now, when they are being affected, the court held that even though you belong to GM category, you can't challenge that. But even though their appointment is affecting you, you can challenge, and the court has granted in my favor, Your Lordship, in this judgment. And last judgment, Your Lordship. Para number 60, page number 52, Your Lordship. Para number 16.
Page number?
52. Para number 16. This is a case where it was contended that I cannot, I am stopped by challenging. Once I have written the examination, I am stopped by challenging the.
ಅದ್ ಬರಲ್ಲ ಬಿಡಿ, ನೀವೇನ್ ಎಕ್ಸಾಮ್ ಬರ್ದಿಲ್ಲಲ್ಲ, ನಿಮಗೇನ್ ಎಷ್ಟಪಡ್ಬಾರ್ದು.
Regarding HK and HK, Lordship, regarding that aspect.
Yes.
Basically, what has held, Lordship, if I read, but in this case,
Yes.
at near E, Lordship, para number 16 near E.
Yes.
But in this case, the government have committed a glaring illegality in the procedure of the candidate examination under the 1955 rules. So, also the method of selection and exercise of the power taking out from the preview of the board and also conduct of the selection of the according to the rules. Therefore, the principle of estoppel of the conduct of acquaintance and has no application in the facts of this case. Thus, we consider that procedure offered in so and so rules adopted by government as well as in action taken by government is not correct in law.
Yes.
So, when there is glaring irregularity, the glaring irregularity, I will tell you, Lordship. Your Lordship may see that the division bench order, it was quashed. The previous final score was quashed. The previous final score was already partly quashed in Geeta Chauhan case, Your Lordship. So whatever the division bench has said that you only conduct with respect to negative marking. Negative marking means the technical examination. Even the review petition that they have filed, I have annexed the review petition that they filed in my regional Lordship. They are discussing only about negative marking issue, Your Lordship. That
Yes.
it would be difficult for them to conduct the negative exam again for negative mark. They have told about the current examination, Your Lordship. Despite there being no decision, they have made such an examination, that also with illegal method, Your Lordship. That without, for 3 years they have conducted in an objective method, descriptive method, giving a long answer. Now suddenly they have given objective method. That has spiked of the passing mark to 83%. Previously, all the examination, the passing percentage of the people who were writing eligibility Kannada test was about 20% to 23%.
Yeah.
Now it has raised to 83%. Why? Because this sort of illegal examination that has been done, Lordship. So the only contention is that rules of the games cannot be changed in midway, Lordship.
Yes.
That's all my submission.
Yes. Can I summarize the contention of the respondents and the impleading, my lords, so that I can answer
Yes.
it? Let's the first contention of the respondent corporation, my lords,
Yes.
is that the C&R rules have no statutory force.
Yes.
Therefore, my lords, they can be given a go by. My lords, the second argument is that the exam is conducted as per the earlier notifications and therefore it can't be challenged. Insofar as Hyderabad, Karnataka, my lords, they would rely at page 237, column number 2. My lords, your lordships may have Mahal writ number. My lords, 2328 of 2026.
No, even 935 also it is there, annexure J.
Yes,
Annexure G.
G, please.
Yes.
Let annexure G,
Yes,
your
sir.
lord, page 211, column 2 is what they have relied upon.
Yes.
But I'll show how, my lords, that might not be helpful. So their contention is column 2 applies.
Yes.
My lords, the next contention they have raised is, my lords, that insofar as recruitment notification provides, my lords, essentially have contended, my lords, that we were all in fact parties in the earlier litigation. We have filed review and thereafter we have. My lords, I'll point out how, my lords, the disadvantage of arguing that is the impleading applicants are still review petitioners before the Supreme Court.
Yes.
And today, my lords, without disclosing that, they are arguing, saying that, my lords, we had filed review, so on and so forth. My lords.
Review, what has happened?
My lords, it's pending. Without disclosing that, my lords, they have filed impleading and saying that, my lords, this person filed review, so on and so forth. Anyway, my lords, it's not a legal.
Yes.
My lords, the first
Dismissed with caution.
the first contention insofar as C&R rules is concerned, my lords.
Yes.
These rules, my lords, have been relied upon by KPCL to defend its action, saying the promotions, recruitment, so on and so forth is in terms of this rule.
Yes.
Today, my lords, for convenience, they would say, my lords, that it has no statutory force. My lords, whether it is statute or not is a different thing. Whether it has statutory force or not is a different thing, my lords. I'm not on the question of statute at all. Whether it is binding on them. That is the issue that I have raised, my lords.
Yes.
Today, it is answered by saying it has no statutory force. My lord, I'm not talking about statute at all. Whether it binds KPCL.
Yes.
The answer is yes, my lord. And can I just rely upon one judgment, my lords? I'll just.
Not dispute that, but they can change it. That's what they're
My
saying.
lords, of course they can change it. But today it is not changed.
Yes.
My lords, the recruitment, I'll just point out how also. Can I just, the relevant portion of this judgment, my lord?
Yes.
On fact, it is changed in 2000 for this exam by a board resolution on facts.
My lords, on facts, that's what. My lords, I am disputing by saying it was a one-time measure in 2014. And on 5/12, I placed that recruitment notification also that it was amended. The recruitment notification as a one-time measure went ahead. So that one-time measure can't be for perpetuation. My lords, in this judgment, would your lordship straight away come to the contention raised, my lords, at internal page 591, para 17. My lords.
Yes.
Shri so-and-so appearing for the petitioner challenges the appointment of respondent number 4 on bylaw expressly requests that vacancy of directorship should be suitably publicized. In the present case, no publicity whatsoever was given to. Even apart from the bylaw, publicity was necessary if appointment was to be fair. Now, para 18, my lords.
Yes.
The respondent's contention. Para 18.2, my lords.
Yes.
Even assuming, though not conceding that there has been violation of bylaw 2, no writ can lie to correct the same as alleged bylaw has no statutory basis, in as much as the Indian Statistical Institute Act 1959 Parliament only declared the institute respondent number 1 as an institution of national importance. And if it has made bylaw 2 for its guide, such bylaws cannot be said to have any statutory force.
Yes.
The bylaw not being having statutory force, the respondents are under no obligation to observe the procedure laid in the bylaws.
Yes.
Now, please have a look at the answer at para 23, my lords. Page 594.
Yes.
That's the contention, my lords, in the middle of the paragraph. Of Shri so-and-so, however, is that the bylaws having no compliance with its requirement cannot in any way affect the appointment of respondent number 4 as director of respondent number 1. Shri so-and-so, however, contended that assuming the bylaw is not statutory, even so, respondent strongly relied upon Ram Dayanand Shetty versus International Airport Authority, so-and-so. It is well settled rule of administrative law that executive authority must be rigorously held to the standards by which it professes its action to be judged, and it must scrupulously observe those standards on pain of invalidation of an act in violation of them. The categorical finding is it will invalidate if there is violation of it.
Yes.
Para 24, my lords. They quote R.D. Shetty and para 24, next page, my lords.
Yes.
In view of the pronouncement of this court, the point it must be held to be obligatory on the part of respondent number 1 to follow the bylaws if the bylaws have been framed for the conduct of its aware to avoid arbitrariness.
Yes.
Therefore, my lord, my submission to your lordships is that these rules must be strictly complied. Insofar as, my lords, the minimum requirement of
Yes.
fixing a cutoff marks and giving relaxation of 5% to scheduled caste and scheduled. My lord, the argument was 2 separate lists are formed. My lord, my respectful submission is that is not the case. I've already produced documents in my writ petition, my lord. I'm sorry, my lord, that's not a part of the writ petition your lordships are holding. In 2328,
Yes.
I have produced the score list and the document verification list.
Yes.
Well, let's the procedure today KPCL says it will follow is written test is conducted,
Yes.
score is published,
Yes.
score will be published. On the basis of score, document verification and final select list.
Yes.
Now, please have a look at page number 181. Argument of the respondent was that we will maintain 2 separate lists.
Yes.
Therefore, relaxation of 5% need not be given at all. I will demonstrate, my lords, how we are prejudiced by it. Page 181, my lords, annexure U.
Yes.
It is the score list, my lords.
Yes.
One common list for all candidates. My lords, no difficulty. Then, document verification will start at page 205, my lords. Here the argument is SC/STs will have a separate document verification list because unless I pass the document verification, I can't go further. Now, 205 is the single.
Yes.
In 205, kindly see what happens, Malad. This is one list. Now, your Lordships, Malad, I was asked to demonstrate how without that 5% marks I am prejudiced, Malad. Kindly come to page 206, Malad. I will demonstrate, Malad.
Yes.
Malad, last 4 candidates, Malad, after 50.
Yes.
Malad, I am assuming, Malad, for the sake of argument, cutoff is fixed at 30 for general candidates, Malad.
Yes.
Then relaxation for all categories other than SC/ST, minimum they have to score 30. For SC/ST, even if they score 25, they will be eligible. Now, please see what happens after 50, Malad. 51 is ST women, 51 and 52.
Yes.
53 and 54 are persons with 26 and 26.
Yes.
Now, had there been a cutoff of 30, these two persons, Malad, 53, 54 would not have been found.
Yes.
Persons belonging to scheduled caste and scheduled category who would have scored above 25, their names would have figured. Malad, I'm asked to demonstrate and therefore I'm demonstrating. Malad, it can be easy to say that I'm on presumptions, but today this is the list and I can only demonstrate it this way and no other way.
Yes.
Therefore, Malad, the minimum cutoff marks, the necessity to prescribe minimum cutoff mark is demonstrated at page 206.
Yes.
Assuming, Malad, they fix it at 25. Then SC/STs below 20, above 20 will get enter, and general categories above 20, below 25 will not enter the field of selection at all. Here, Malad, they have made just one list. Now, a scheduled caste, scheduled tribe category candidate who is not found in document verification will not proceed further for selection at all. So whether they publish 2 select lists at the time of final selection, Malad, is immaterial because these category candidates would have already lost out at the stage of document verification itself.
Yes.
Malad, therefore, my submission is in the 1:2 cutoff list itself, Malad, I am able to demonstrate. And annexure V, page 205, Malad, if your Lordships were to see the list, it is.
Yes.
It is a list which is prepared on the basis of scores that have been secured, not on the basis of reservation. Kindly see the arrangement of names, Malad. 73, 73, 73. So it's in the
which page?
Page 205, Malad.
Yes.
How the list starts.
Yes.
Therefore, Malad, it's in the descending order.
Yes.
The top scorer is at serial number 1, and the last scorer, Malad, is the person with the least score.
Yes.
Malad, similarly, Malad, your Lordship, it is available, Malad, in few other lists which your Lordship, Malad, I can point out in that same thing at page 211, Malad. 210 the list starts, 211. Malad, kindly see the last 2 persons. I am assuming, Malad, that there's a cutoff marks of 30, 35 or whatever it is, Malad. This is how it will work. Therefore, Malad, this stipulation in the C&R rules, insofar as cutoff marks, in my respectful submission, that is not amended anywhere. It is not given a go by any resolution which is placed before your Lordships. Therefore, Malad, stipulation of that is mandatory. I have already relied upon judgments to say rules are mandatory. Now, Malad, insofar as the Hyderabad Karnataka is concerned, Malad,
Yes.
while your Lordships are holding that paper book, can I just draw your Lordships' attention to page 233, Malad? Chronologically, I'm just explaining.
Yes.
233.
Yes.
10, 12, 25, clause 3, Malad.
Yes.
ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ 3625 ರಂತೆ ತಯಾರಿಸಲಾಗುವುದು.
Yes.
Next, Malad, since objections were filed, they said we will follow both 1611 and 10, 12, 25, Malad.
Yes.
Malad, kindly see what 1611, page 235, 1611 2016 says. clause 2, my lords.
Yes.
This is in the year 2016, my lords.
Yes.
ವಿವಿಧ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಿಗಳು ಇನ್ನು ಮುಂದೆ ಮಿಕ್ಕುಳಿದ ವೃಂದ ಹಾಗೂ ಸ್ಥಳೀಯ ವೃಂದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳಿಗೆ ಅರ್ಜಿ ಆಹ್ವಾನಿಸುವ ಅಧಿಸೂಚನೆಯನ್ನು ಪ್ರತ್ಯೇಕವಾಗಿ ಹೊರಡಿಸಿ. I'll stop here, my lords. This was followed. 2 different recruitment notifications for HK and non-HK in this recruitment. They follow up till first paragraph. Next one. ಪ್ರತ್ಯೇಕವಾಗಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ಕೈಗೊಂಡು ಆಯ್ಕೆ ಅಂತಿಮಗೊಳಿಸುವುದು.
Yes.
Therefore, my lords, there had to be 2 different selection procedures, not method, my lords. For HK different exam, non-HK, my lords. This was clarified in 3/6/25, page 236, my lords, which they say they will follow.
Yes.
Let's, can I just read page 236 minutes?
Yes.
First paragraph, Malad, in the center, Malad, Sarkarada Dinanka.
Yes.
ಸರ್ಕಾರದ ದಿನಾಂಕ 15/6/2022 ರ ಸುತ್ತೋಲೆಯಲ್ಲಿ ವಿವಿಧ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಿಗಳು ಸ್ಥಳೀಯ ಹಾಗೂ ಮಿಕ್ಕುಳಿದ ವೃಂದದ ಹುದ್ದೆಗಳಿಗೆ ಪ್ರತ್ಯೇಕ ಅರ್ಜಿ ಆಹ್ವಾನಿಸಿ ಪ್ರತ್ಯೇಕವಾಗಿ ಸ್ಪರ್ಧಾತ್ಮಕ ಪರೀಕ್ಷೆಗಳನ್ನು ನಡೆಸಿ ಪ್ರತ್ಯೇಕವಾಗಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ಕೈಗೊಂಡು ಆಯ್ಕೆ ಪಟ್ಟಿಗಳನ್ನು ಅಂತಿಮಗೊಳಿಸಲು ಸೂಚಿಸಿದ್ದಾಗಿಯೂ ಸದರಿ ಸೂಚನೆಗಳನ್ನು ಪಾಲಿಸದೆ ಅನೇಕ ಪ್ರಕರಣಗಳಲ್ಲಿ ಒಂದೇ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ಒಂದೇ ಪರೀಕ್ಷೆ ನಡೆಸಿರುವ ಹಾಗೂ ಪ್ರತ್ಯೇಕ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ಒಂದೇ ಪರೀಕ್ಷೆ ನಡೆಸಿರುವ ಪ್ರಕರಣಗಳು ಬೆಳಕಿಗೆ ಬಂದಿರುತ್ತದೆ. Like in this case, 2 different notification, 1 examination. Then, my lords, please come to 237 clause 2.
Yes.
This is where they say, if you have already conducted the examination, 2 recruitment, 1 exam, this is how you have to publish the select list.
Yes.
Now at the bottom, my lords, ಮುಂದುವರೆದು ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ವೃಂದದ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ಈಗಾಗಲೇ ನೀಡಿರುವ ಸೂಚನೆಗಳಂತೆ ಕಡ್ಡಾಯವಾಗಿ ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ವೃಂದದ ಹುದ್ದೆಗಳ ನೇಮಕಾತಿ ಪ್ರತ್ಯೇಕ ನೇಮಕಾತಿ ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸಿ ಪ್ರತ್ಯೇಕ ಪರೀಕ್ಷೆಯನ್ನು ಕೈಗೊಳ್ಳಲು ಸೂಚಿಸಿದೆ. Now, my lords, this 3/6/25 was prior to the exam, and on 10/12, my lords, they say we will follow this. Today, my lords, they want to take shelter under clause 2 and say that, look, I've conducted 1 exam, what to do? My lords, after having said we will follow this, they should have conducted 2 examinations, and by not conducting, my lords, again the question of prejudice has been raised, my lords. What happens, my lords, even according to their own argument, is most meritorious in HK will come in non-HK.
Yes.
Now, my lords, thereby non-HK candidates, 1 will lose out. Whether HK wants to come to non-HK or not is a different matter. By force, they can't, my lord, say that he has to come here. That's a matter which is being agitated before the division bench. Therefore, I will not argue it here. But if prejudice is being argued, this is the prejudice. And when rules are there, my lord, they can't say that we will not follow because they have to show prejudice. My lord, that's my submission. And insofar as, my lord, the contention, my lord, that the earlier judgments were only insofar as negative marking, my lords.
Yes.
My lords, no doubt it was only insofar as negative marking. Therefore, my lords, we are here. If those issues were already decided, it possibly is not. My lord, the other contention that we had filed reviews on and so forth, my lords.
Yes.
Insofar as first writ petition, first petitioner, my lord, he had filed review. He lost before Supreme Court. That can't be held against him. Even then, my lord, even after all of this, he has challenged the examination before the exam.
Yes.
Having resisted that, my lords, they can't say today that exam is conducted. My lords, this argument of the respondent that 18,000 candidates have taken up the examination, therefore it can't be cancelled, is considered at page 118, para 27, my lords. Division bench in the earlier round, exact same argument. 18,000 candidates are there, selection is going on for a long time, prejudice, so on and so forth.
Yes.
Page 118, para 27, my lords.
Yes. 118.
Yes, my lords.
In which
In the writ petition, your lordships are holding 2328.
2328.
Yes, my lord. I'm sorry, 2328, my lord. I'll just tell your lordship. I'm sorry.
Which is the paragraph?
Paragraph 27, which your lordships would find at page
Yes.
number 136, my lord.
137.
137.
Yes.
It is contended by the private respondents that around 18,000 candidates appeared for 2024 and the results were announced with only 12 candidates have approached this court. Hence, it is argued that public interest prevails over individual rights and 2024 examination should not be cancelled. This submission is, however, superfluous. If an examination is required to be conducted, it must be in accordance with the prescribed rules, regulations, terms, and conditions. And an examination conducted otherwise is unsustainable. Now let's kindly mark the first sentence. If an examination is required to be conducted, it must be held in accordance with the prescribed rules, regulations, terms, and conditions. An examination conducted otherwise is unsustainable. The number of candidates who have brought the cause before the court is immaterial. What matters is the cause itself. Once it is established that the examination was not conducted in compliance with the required rules and regulations, the validity of such examination can be examined regardless of the number of candidates who participated or the consequences of declaring such examination invalid. Nobody has challenged this, my lords. Or people who challenged have been unsuccessful. Therefore, my lords, today, the impleading applicants or the respondents can't contend otherwise, my lords. That's my submission, my lords.
Page 143 itself, in that same judgment, court has said, respondent hereby directed to conduct the re-examination expeditiously within a reasonable time for all candidates appeared in the examination on 18% to the notification dated 3/8/2000. We have done it as per the notification dated 3/8. Now what is saying, again finding fault. Therefore, I submitted, as the principle of res judicata, he cannot appropriate and reprobate. Now, having done it, he cannot keep taking new grounds at every level of after the examination is concerned.
Just last 2 points, I'll just clarify, my lords. This is the latest decision of the division bench, and which is confirmed by the. I'll just. My lords, just paragraph 3 in that, my lords. My lords, paragraph 3, my lords. Page 22, cost title itself is lengthy, my lords. Please see how KPCL defends its action, my lords. 22, internal page 22, para 3.
Yes.
Today it is confirmed by the Supreme Court, my lords, and I have produced. The petitioners are all graduate engineers in different batches appointed in assistant engineer. The private respondents were initially appointed as junior and however obtained degree got promoted and appointed by transfer as. The recruitment and service conditions of AE in KPCL are governed under the provisions of the Cadre and Recruitment Rules 1992 of the KPCL. Well, this is the contention of the petitioners in a different matter, that they are governed by Rules 92. I have only produced the replaced rules, my lords.
Correct.
Today, my lords, they can't contend, my lords, that they are not governed by it. It is not statutory force. My lords, insofar as amendment of the rules, my lords, in the writ petition that your lordships are holding, my lords, I have produced the amended rules. Can I just clarify, my lords, only for the sake of clarity? Amended rules, my lords, your lordships would find it at page number 176 onwards.
That
2328.
176
months.
Yes.
First 3 point to the my lords, kindly existing is there, amended, my lords. My lords, in the existing JE, AE and equivalents were all clubbed together, my lords.
Yes.
At the time of amendment, they said recruitment to the post of JE, AE will be made by selection, considering the marks obtained in the qualifying exam and the written test. Therefore, my lords, it's two, not two tests. In my qualifying exam, qualification is B. My marks in qualifying exam and in the written test. Therefore, my lords, I am not seeking for amendment of the recruitment notification. I am only saying you have to consider the marks in the qualifying exam, my lords. Now, kindly come to next page, 177, 3.3.3. for the, your lordship will get on the right side.
Yes.
For the written test to be conducted, the MD will nominate the authority to conduct the written test, specify the minimum pass mark for general category with minimum with relaxation up to 5% for SC, ST. Now, my lords, next sentence. This is as in the old rules. Such of the candidates to the post as in 3.3.2A2 and 3.3.2B who pass the written test will be only allowed to appear for viva voce.
Yes.
My lords, I don't fall in this category because I am under 3.
Yes.
If your lordship were to see the previous page, my lord, 176. Kindly see subclause 2. That is for recruitment to the post equivalent to JE and DE.
Yes.
I'm not on the equivalence at all. I'm on JE and DE. So I am under 3.2A1.
Yes.
If your lordships were to read 176 and 177 together, it means there is no amendment to anything that is required. They only have to consider my qualifying marks because the rules stipulate. My lord, the resolution that they say, my lord, is given a go by. I've pointed out how it was only a one-time measure and thereafter recruitment has taken place.
Yes.
Just clarification only on this point. Your Lordship.
Over.
That's all.
Only on this point, Your Lordship, may kindly take the statement of objections in.
In that second examination.
That is what I'm answering. Page 112 in of the statement of objection in 2328, my lords.
Yes.
Code officer, brief note to other section.
Yes.
Page 112, my lords.
Yes. 112.
Please, my lords.
Yes.
The board was informed, minutes of the meeting of 240th board meeting dated,
My lord, in the objection statement.
statement of objection.
Yes.
Yes.
Dated
Yes.
20th September 2014.
112. Annexure R5.
R5 dated 20th September 2014. Board was informed that authorization to MD to carry out recruitment process for the entire level post of so and so in 2 stages, keeping in abeyance the provisions of the oral bar written test as a one-time measure and take action with regard to assistant post. 2 things, 2 stages. Total number of sanctioned posts, my lords, was.
You are saying that one-time measures in 2014.
Correct.
After that, you have conducted one exam.
No, 1 second. 2 stages it says, my lord.
Yes.
So notification is for 1724.
Yes.
In 2 stages, first stage was 615. Second stage, which we are concerned with, my lord, is 622. Your Lordship, can you take my brief note for a moment, my lord, which I have given today, my lord. Today, which I have given, my lord. Page 7, my lords.
Citation. Yes.
Page 7, my lords.
Yes.
Right at the bottom, details, my lords.
Yes.
Total sanctioned post, my lords. 1724, right at the bottom, my lords, page 7.
Yes.
1724. Number of posts filled by last recruitment in the year 2007.
Page 7.
This table form, my lords.
Oh, first you have given, not today.
That is given on 9th February.
Yes,
Today.
no. Today. Yes.
9th February. Correct, 9th February.
I thought today you have given that.
Today is 9th February. Ee ತರ ಇದೆ ನೋಡಿ 9/2.
9/2.
Brief note ಅಂತ ಇದೆ.
No memo for production of document.
No, brief note.
And citation you have given today.
And one more brief note. First, we give a brief note which I read out the judgments, my lords.
Yes,
We
judgment.
give to, you got extra copy? In fact, code officer ಈ ತರ ಇದೆ ನೋಡಿ.
Brief note.
ಅದು
Yes.
Page 7, my lords.
Page 7. Yes.
Your Lordship pointed out the resolution of the year 2014 and what it meant, my lords.
Yes.
See page 7 right at the bottom.
Yes.
Total sanctioned post is 1724.
Yes.
Number of posts filled up by last recruitment in the year 2014 is 615. The present notification, my lords, is the second stage. Number of posts for recruitment conducted is 622.
Yes.
Number of candidates who wrote the Kpcl. So 9 so and so. So therefore, my lord, what it says is 2 stages. I need not call for 1724 at a time. It was you bifurcate the whole notification into.
Amendment is applicable to both. That's
Yes,
what one-
yes, that's why I'll read it. Keeping this in mind, I'll read it, my lords. Board was informed of the authorization MD to carry out recruitment process for the
Yes, read.
for the entire entry level post for assistant post of assistant accounts and assistant administration, AE, JEs, chemical supervisor and chemical in 2 stages, keeping in abeyance of the provisions of oral or written test as a one-time basis and the action taken with regard to assistant commissioner. The problem is from 2014 to 2026, 12 years, my lord, the second stage has not taken off at all.
Yes.
So therefore, if it was conducted in 2014, my lords. With regard to the selection of technical post, wide variation in marks is observed between VTU colleges and anonymous college. It is felt desirable to consider selection on the basis of marks obtained in the written test conducted by reputed institution. MS so-and-so has come forward to conduct this case to so-and-so to meet the.
IMB conducted 2017 exam also IMB.
But all this examination is, I mean, my learned friend Mr. Malo, IMB has conducted this examination also, Malo. So therefore, number of posts to be filled at 2 stages.
Yes.
So therefore, Malo, it goes back to 2014, past 12 years. Ultimately, Malo, it is not the, as rightly pointed by the division bench, Malo. We are not saying that number. This time, the whole judgment was based on no prior. The question before the division bench was negative marking. What the court said was
That has been challenged in the earlier writ petition.
After selection.
after selection.
After this
Selection.
No, what the court ultimately
it was
was.
challenged earlier after the score list was published, but what was stayed was only issuance of appointment order. So
So what-
final select list was published.
Ultimately, what the court was saying this, did you inform the candidates before they entered the examination all about negative marking? Factually, in fact, our submission was it was not informed. Our only argument was in the earlier all ticket, not this all ticket, not the second examination. First examination, Malos, in that all ticket it was. Court said if you're not informed, doesn't matter the number of.
Want to reply for that Kannada students, that citation, yes, locus.
Please, Malos, insofar as Kannada.
Yes. Right, yes, sir.
And please, Manoj, the facts are totally different insofar as those citation is concerned, Manoj. The reason being, Manoj, this one. First of all, Manoj, they have not challenged the examination in this.
Yes.
Most important, nobody has challenged the examination. Here, 1911-2025 examination, Manoj, is not challenged. Notification is not challenged with regard to
19, 2025.
5 notification regarding Kannada examination is not challenged.
Oh, they have appeared and he has challenged in this writ petition.
No, Manoj. They are not challenged the notification.
They did not challenge it before the exam was. They not challenge it before.
Manoj, the slight difference in these judgments here is, Manoj, they were prejudiced.
Yeah, just we will make it facts correct. When he has he challenged that notification,
My learned friend says,
935, 953.
my lord,
Challenge it after the exam.
Your Lordship will give you the date, give your Lordship the date of the writ petition filed, Manoj.
Yes. 1911-2025 is the date of exam.
Date of the exam.
Date of exam. This one. Date of examination is 20.
That's 28/12/25 is the date of examination. 19/11/25 is the date of notification.
1911-25 is
Date of notification,
Ah,
impugned notification. Exam was conducted, Kannada exam on 28/12/25 at 3 p.m.
Your Lordship may kindly take the date.
no, you are challenged, but you are challenged in the 26.
My lord, the
13,
notification is dated 19/11/2025.
Yes. Yes,
The date of examination is on 27th December 2025, my lord. 28 December 2025.
Yes.
The date of filing, my learned friends, 13th January, my lord.
Yes.
That is after the examination. And what is important, my lords, he is not a candidate who has written his case is, my lords, he need not take the exam because he studied Kannada. The person who has not studied Kannada, that's the point he's saying is because you have made it multiple choice, they are able to score more. That is why he is affected. That cannot be a ground for the simple reason, my lords. The way the paper we set, it is for us to decide. Nobody can say that it should be in this format or that format. So he cannot question the format because he visualizes it. If it was not multiple choice, they would have scored less. If they had scored less, I would have been more. It is all on the basis of assumptions and presumptions. So therefore, my lords, in trying to go into what would have been the question paper, what marks they would have secured. So therefore, my lords, is not agreed or prejudiced. The two judgments which my learned friends ought to rely upon, my lords, in both, by action, my lords, they were agreed, my lords.
Yes.
The lordship may kindly see page 15, paragraph 22, page 14, my lords.
Yes.
Paragraph 22.
Same recruitment.
Which judgment you are?
First judgment, my lords. First, they relied upon first two judgments to show he has locus, my lords, with regard to Kannada examination.
Yes.
The other question which must turn our attention is to whether appellant had locus standard to challenge the mode of recruitment of this. The High Court held that since they were not of reserved class, they did not have the locus to challenge the mode of recruitment, so and so, so and so. While accepting the principle itself, we do not find it pertinent in the factual scenario before us. The unrefuted factual position is that by virtue of retrospective regularization, several of the respondents gained seniority. That is not the case here. The facts that took over the appellant in the light of direct impact on them.
Yes.
So therefore, my lord, this is a case of retrospective seniority because they belong to the same category, my lord.
Yes.
The next judgment which is sought to be relied upon in page 41, para 49, my lords, is again the state of Rajasthan, para 49, third line, my lord. The state of Rajasthan and mitigated such candidates who had taken concession of age against unreserved vacancies, which resulted in displacement of large number of candidates. That is not the case here, my lord.
Yes.
There's an additional examination, that's all, my lord, for people who have not taken. So we have set the examination, no fault can be done with the examination. He's saying implication of the examination, that cannot be a ground at all, my lord. It's like something like, my lord, saying we have given the fifth question, negative marking. We said that if you don't answer, there'll be negative marking. So that there's no negative marking, we made a fifth column. We say that if you put that, no, there'll be no negative. Nobody can, case where no prejudice is caused.
Yes.
Sufficient. They are silent.
And last one judgment.
Where was the jurisdiction to conduct the examination? Where was the order for them to conduct the Kannada exam? That on that fact, they throughout their silent, your lordship. In their objections, in their everywhere they're not taking up that aspect. They have to answer everything.
My lord, if you take it to a logical conclusion, my lord, if you don't conduct the examination, they say you should have conducted the fresh examination because your lordship, Hyderabad, Karnataka, my lord, there's one judgment, my lord, which your lordships are pleased to say, observe at paragraph 81 and 82. Is what covers copy code of copy code. I will give it to you. Sorry.
It's a division bench as you only said.
This is pending in division bench, my lord. All of us are arguing against this for this. My lords, the issue here. No.
As of now, what the
My lords, it is no. The recruitments are also state recruitment of school teachers, professors, Kpcl, police. All of it is state, my lords, because of this judgment. Of course, after he explains, my lord, I'll be able to.
No, therefore, my lord, your lordship need not go into that question.
Yes.
It's pending before. Therefore, my learned friend, the argument will not hold good insofar as that argument is concerned. I didn't want. I am only replying to my learned friend's argument.
That was a case where after
No,
the
then I'll rely on this
exam,
judgment.
people are being migrated.
Rely on
This
this
is not a
judgment.
case of migration. This is conducting two exams for two recruitments.
Yes.
They have merged two recruitments into one. That was not the case there. There they merged and they said it can't be done. Here, Manoj, two recruitments. And in so far as, I'm sorry, Manoj, just two, I forgot to mention. Page 69 of my list of citations have shown, Manoj, how executive instructions can't override rules.
That is there.
Yes, page 69, specific paragraph. But insofar as one petitioner's conduct who said he was in review and then SLP dismissed all of that, but I just wanted to bring to your lordship, impleading applicant number 1, my lords, amongst various others, review is still pending. I'll pass on the number, my lords. in,
Not allow any application for implementing.
very well.
They are
No, my
commenting on
lord,
that.
those are all
I agree
arguments
with my
for
learned
prejudice,
friend on this
therefore on
point,
that
my
I
lord.
should make it, my lord.
Both the petition and the respondent should be dismissed with caution.
No, he Prithvi knows better because he has appeared earlier.
Yes, my lord, all of us, this side and that side, all of us.
Yes.
Grateful to
Yes, reserve for order.
One, we are not asking for a re-examination in Kannada, Your Worship. What we are asking is the older Kannada exam, what is after Geeta Java, at annex E2 is there, Your Worship. That way we appealed, Your Worship. We got-
No, that you first day on the Nagarala has
Yes,
argued
yes,
that.
what
Yes,
we are saying.
yes.
Passing of the content.
Yes, yes, yes. Our time but soon ready ಆಗ್ತದೆ. Yes, yes, yeah. Yes. Continue, ma'am. Yes.
The dates which are not listed, I just pass on the numbers after this.
Yes, yes.
Continuation of list, serial number 52, Puttegowda K for petitioner, Pradyumna L. Serial number
Yes.
52,
Yes. Is this matter?
Lord,
Yes.
kindly pass over senior counsel is engaged in Kotal 1.
Portion of it is covered by this court information decision allowance 195.
Yes.
Today, Kpcl KSLP was referred. It has been dismissed. The lordship would